Well, good morning, everyone. We're going to go ahead and get started with our discussion today about disability discrimination. First of all, let me introduce myself. My name is Dante Bonner. I am the Educational Outreach Training Coordinator with the Florida Commission on Human Relations located in Tallahassee, Florida. My discussion topic this morning is disability discrimination, your rights, your roles, and responsibilities. And before I get started, I want to first thank Sarah Faley and the Family Cafe staff for inviting me. I'm a newbie here, so don't hurt me too much, for all the veterans here. But I'm grateful for the opportunity to talk and share with you about this particular important role. Just to give you a little bit about myself, I was born in Fort Myers, Florida. However, I was raised in the military. So my father is a U.S. Army veteran. We have any veterans in here? Family, hey, I'm a military brat, so I get it. So I want to thank you for your service and for your family's service. As my mom said, I was in the service too, because I had to be right there with them. I've traveled extensively, lived in Germany, lived in Alaska. I've been about 35, 38 states or so in the country.
Which was your favorite?
Ooh, between Germany and Alaska.
Yeah, Germany is
Awesome. And so graduated from Florida A&M University with a School of Business and Industry. With business degree, and I have been with this agency and just celebrated 26 years of service. And so we're going to talk about what we do here and what your roles and rights are. So first of all, thank you so much for getting up early in the morning. So stretching out, everybody got their coffee, got your bagel or cereal. If you need to stretch a little bit, look, I'm not a morning person myself, so I definitely understand. If you got to take that little sip, just not too loud because I might get jealous. Okay, so how many of you all, prior to flipping through, have ever heard of the Florida Commission on Human Relations by a show of hands? Okay. That is my typical response because we are probably one of the smallest agencies in the state, but yet we're like a firecracker, small yet mighty. And I always tell my boss, the executive director, Ms. Cheyenne Castilla, this is why I will always be employed, because everybody's got to know about us, because we are so important. So that's why I go across the state talking about who we are, what we do, and what rights and responsibilities and the role that each person has in this state has. So, Florida Commission on Human Relations, we are established in July of 1969, so we've been over 50 plus years, and so we are the only state agency that investigates allegations of discrimination complaints, meaning that if you feel like something's treating you differently, then we are the only state agency that does so. Now, we have federal partnerships, federal, EEOC, for employment aspect, and housing, HUD, Housing, Urban, and Development. So what that basically means is if a complaint is filed with us, that we are substantially equivalent or we have the same authority because of our partnership. So filing with us is also like filing with them, except that your federal and state rights are covered. And I'll kind of briefly touch upon that. As an agency, we cover 4 areas. And it's important for me to distinguish that, and I'll kind of talk about that a little more in my presentation later on this morning. But employment, fair housing, certain public accommodation, and state whistleblower retaliation, which means that state employees can file complaints against state agencies if they're, quote, blowing the whistle, and as a result of blowing the whistle, something happens to them. It's not just blowing the whistles. Another organization handles the actual whistleblower portion. We deal with what happens to them after they told on them, saying, you shouldn't have done that. Well, fine, I'm gonna get you. So that's what we handle. Also, another service that we provide is mediation. Now, when we talk about mediation, that's after a complaint has been filed with us. We don't do outside mediation saying, my neighbor wouldn't put a fence on the other side of y'all, can y'all do something about it? No, that's another agency organization, and so we'll refer you to them. And then education outreach. Hi, that's me. All right. So one of the things about my presentation, I don't like to say presentations, I don't like to say trainings. Most of the time people say, another training, I'm so tired of that. I like to have conversations. So what you'll find about me is I'm going to be a little bit interactive. So I'm going to be like your second grade teacher. So I may ask you a question, and if nobody gives me an answer, I'm going to say, you know, that type of thing. So because the important thing is to be engaging, to get information. Yes, I am sharing you the particular knowledge, but you're going to have questions. You're going to have thought process. So we're going to go back and forth, back and forth. Anybody see the French Open? Anybody a tennis fan? Okay, I guess that's just me. It's like tennis going back and forth, back and forth. I love playing tennis, so, you know, that's the thing. So, first interactive question, and I know we are recording, so I'm just going to repeat some of your particular answers. What is discrimination? We use that word, that blunt. I've been treated differently. I've been discriminated against. So, what is your idea of what discrimination is? Just real quick. Yes, sir. Is broadened with people with disability. All right, anybody else? Yes, ma'am. Being excluded intentionally. I like that. Did you look at my presentation?
What? Sorry.
Did you look at my presentation? That, you know, that's not cool. So, the actual word of discrimination is the treatment of a particular group of people differently from any other group who are not in that group, or the practice of treating people differently or companies in an unfair manner. Now, this is early in the morning, so I'm going to ask you a very simple question. How many of you all are coffee drinkers? Just raise your hands. Okay? What if I said to you that I will not give you a house or hire you because you drink coffee?
That's discrimination.
That's discrimination. I have treated you unfairly. Now, is that right? Is that unfair? Is it unethical? Is it illegal? That is the question. When we're talking about discrimination, particularly from a legal aspect, it's not a matter of were you treated unfairly. It's was the discrimination illegal. So I have discriminated against you because of coffee. But tell me a statute in the state of Florida, in your local ordinance, or in the country where it says a protected basis is coffee. That is what I want to try to get people to understand. One of the things I like to tell individuals, there is a difference between facts and feelings. The feelings are, I have been treated unfairly. But the fact is, was it illegal? And guess what? They conflict. In our agency, we have the responsibility of what are the facts concerning the case to determine whether or not were you treated differently. Now, talked about the theory and aspect of it. What gives us our authority to do so? Because guess what? We got a little bit. Not too much, but we got a little bit. So, first of all, the federal law, Title VII of the Civil Rights Act of 1964, Title VIII of the Civil Rights Act of 1968. This first one deals with employment law. The second one deals with fair housing. So as I told you before, we have a partnership with HUD and EEOC. So this gives us that particular authority. Then also, I think everyone, if you're here at Family Cafe, if you're not familiar with this, I think I'm going to come back and teach a course on what this is. Americans with Disability Act, ADA. So we have the authority under ADA to investigate our complaints. Also, Age Discrimination Employment Act, federal law. So those are all the federal guidelines. Now, Chapter 760 of the Florida statute is the equivalent to all of these. So basically, it is the state version of this. And this is where our agency has our full authority because we basically mimic the law of the federal government. And then finally, as I told you about the whistleblower, Chapter 112. I'm not really going to be dealing with that too much, but I wanted to tell you, this is what gives us the authority to investigate and to make decisions whether or not persons have been discriminated against. Now, what I want to share with you now are protected classes and laws in the state of Florida. Do we have any persons that are not from Florida? Raise your hand. Oh, great, we got all from Florida for readings. Awesome. The reason why I bring this up is because on the federal level, the laws are going to be the same. But on the state level, it could be expanded. For example, in the state of California, they have 21 bases or classes that a person can file a complaint under. In the state of Florida, we have 7 or 8, just like the federal government. And I bring that up is because there may be certain situations on the federal or state level that we can cover, but a local ordinance has an area where we cannot cover. And I'll explain to that in a second once I tell you what those bases are. They are race, color, religion, national origin, sex, which covers gender identity, sexual harassment, sexual orientation, age, which is employment and public accommodation complaints only, disability, retaliation, and familial status. And this comes under housing and public accommodation cases, and marital status, which is a state-only claim filed under employment law. So we're going to break those down. First of all, race. Under the federal EEO-1 guidelines, this is talking about the classification as far as how a person identifies. And what has been established is race is black, white, Asian, American Indian, Alaska Native, Native Hawaiian, or other Pacific Islander. As I stated before, I used to live in Alaska. Yes, the natives do live in igloos, some of them up north. I didn't believe until I got there myself. But yes, they are considered a race, all right? Color, variations of skin tone, how light or how dark someone actually is. We see this typically in the African American community, the Hispanic community, and the Caribbean community. So they're being treated differently because of how bright someone is or how dark someone is, okay? Religion, a sincerely held belief, practice, observance. So this is covering traditional, whether it's Catholicism, Protestant, different denominations, Baptist, Methodist, Episcopalian, non-denominational, those that do not subscribe to agnostic, atheists, or they believe in everything, or the ones that are not as familiar, Jewish, Islam, Buddhism, Shintoism, and tree hugging, Satan worship, naturalist. If you have a sincere held belief, then it is covered. And ladies and gentlemen, there is no religious test to say, are you really a tree hugger? I don't see you hugging every particular tree. Well, I only hug tree on Tuesdays. But that is a protected basis, okay? National origin. We have 2 different perspectives. The country of origin, so persons who will come into this country, Nigeria, Australia, Japan, their rights are protected, as well as your ethnicity. If you were born here, but your heritage is of a different country, from being Hispanic or being Venezuelan or being Norwegian or being Egyptian, or whatever the case may be, your rights are being protected. Now, sex. We have different classifications on here. Now, I will tell you that given the new executive order by the current administration, some of this has been modified on a case-by-case scenario, particularly where it comes to transgender and gender identity. So depending upon the allegation, it may be something that we can or may not be able to handle, but it is a case-by-case scenario, okay? Sexual harassment, basically quid pro quo. So sexual harassment would be like this: you know, you look really good in that hat, young lady. So how about we go out and I'll give you 3 months off your rent. You don't want to go out with me? Fine. I will put you on the waiting list. I have just sexually harassed her just because she didn't want to go out with me. She hurt my feelings. Or another aspect is you're living in a particular place and you go to the mailbox and, hey, good looking, how you doing? Okay, he has a snaggle tooth, he's unkempt, and doesn't smell too nice. And he works for the place. And I'm fine. Hey, how you doing? You ain't gonna go out with me? Okay, leave me alone. Well, fine then. See if you get your maintenance plumbing fixed. potential sexual harassment. And then finally, sexual orientation. Now, let me be very clear. Sexual orientation in the state of Florida is not a protected basis. Under the Supreme Court case of 2020, Bostock versus Clayton County, it identified that sexual orientation is a type of sex discrimination. That's the first thing. However, based upon the executive order by the administration, there are certain limitations also that have to be looked at to determine whether or not that is going to be filed. But again, I tell everyone, do not be your own lawyer. We cannot give you legal advice. We just sleep at a Red Roof Inn. Let us do the investigation, determine whether or not it's something that could be handled. So don't just make the assumption, oh, they're not going to do anything or anything like that. What was the name of this presentation? Your rights, your role, your responsibility. And so there's a lot of noise and a lot of chaos out here. And my job is to help try to put a little bit of sunshine to say, maybe not so much, just to make sure you're properly educated. Age. Yes, there is a law for state and federal discrimination based upon age. Refusing to hire any individual with respect to compensation, terms and conditions, depending upon how old you are. How long you gonna be in this position? When you gonna retire? You holding up somebody's space. You might have heard those comments. That's actually harassment. Now, on the federal level, remember we were talking about those federal laws, the ADEA, Age Discrimination Employment Act? If you are age 40 and above, you are covered under the federal law. Please don't ask me. I did not make up that rule. I had a conversation. Are you trying to tell me 40 is old? No, ma'am. No. I did not say 40 is old. They just made this little cutoff. However, under state law, Chapter 760, it is birth to death. So all my young people, 16, 17 years old that have a job, you can actually be discriminated against and you can actually file a complaint with a parental or a guardian's assistance. But yes, you could be mistreated because of your age. Wow, I didn't know that. Yes, so if somebody's bothering you on the job, they're not treating you due diligence, you go tell your loved ones, hey, I think I'm being mistreated. And guess who investigates that? Hi, that's us. And of course, the biggie, disability. So one of the things I need to have clarification is different organizations and entities have different definitions of what disability is. As I stated before, I'm a military brat. My father served in the military in the U.S. Army. And what their definition of disability, because I get 20% disability, I get 40% disability, they get the different ratings. That is not the same thing concerning when a complaint is being filed. These are the different things that is looked at to determine whether or not a person is disabled. Number one, a physical or mental impairment which substantially limits one or more major life activities. What is a major life activity? Walking, talking, breathing, working, driving, taking care of oneself, or having a record of having such an impairment or being regarded as having an impairment. So having a record of, let's say you had cancer, did the chemo, did the treatment, got out the hospital, ringing the bell, ding, 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 hey, we're celebrating you don't have cancer. I go back to work. Your job gives you an applause, great, wonderful. A couple months later, there is an awesome position that I know it has my name written all over it, and I apply for it. And they say, this Dante will be awesome for this position, but this requires a lot of work and travel. And he was already out with cancer, and we kind of really need for him to be here, and his cancer may come back. So we may not want to hire him because if he's out, then who's going to do his job? I have just been regarded. That's illegal. Or being regarded, that was a record of, excuse me. Now, being regarded as having an impairment is, we have beautiful sunrises here in the state of Florida, and I want to have an overlooking view, so I'm looking at this wonderful apartment. Fortunately, it doesn't have an elevator, but I'm in a condition where I can walk up and down the steps, so I'm going up the steps, but I'm breathing a little heavy. The property manager's looking like, he's breathing awfully heavy. He might have asthma. If he has asthma, he could have an asthma attack. If he has an asthma attack, he could fall down these steps. If he falls down these steps, he could have a lawsuit. I don't think we want to give it to him. So let's just tell him it's unavailable. So they have now regarded me as having a disability, when the fact of the matter is, I'm out of shape. Going up steps is tiring. It's not because I have a breathing condition. So do you see the different aspects on how persons with disability could be treated? And that's something that we investigate. Marital status. This is talking about the state of being married or unmarried. So single, married, divorce, or my favorite one, it's complicated. So it is not who you are married to. I'm filing a complaint because my spouse is the president of Disney. And because they're the president of Disney, they don't want to hire me because they think I'm biased. That would not be a complaint we take, because it's not a matter of being married to the president of Disney. Even though there's probably some major perks with that. But that's not what that is. It's what you are being married. And that is a state-only claim. That's not dealing with housing. It's not dealing with public accommodation. It's only dealing with employment. And then familial status. This is important for those that have children under the age of 18. If you feel like you're being treated differently in the area of housing and public accommodation. So public accommodation would be restaurants, hotels, motels, stadiums. So guardian ad litem, foster. Also, being pregnant is also considered having familial status. It is not, unfortunately, dealing with caring for loved ones that maybe your grandparents or your loved ones who are aged. So that's not familial status. Now, if it's a person with disability, then the complaint may be because of a disability, but not simply because of you having older loved ones that are under the age of 18. And this is for housing, but it's also for public accommodation as well. And retaliation. This is the act of taking an adverse action against an employee for engaging in a protected activity. So I feel like someone's mistreating me. I go to HR. I go complain. They're mad that you complained on my friend. Now, all of a sudden, I write you up or I discipline you in some type of way. That would be what would be called retaliation. So with all of those particular things, question time. What do you think of all those bases is the number one fair housing issue basis, as well as employment as well, but for fair housing purposes? What do you think is the number one basis that I just gave you? And if you need help, I can go back and remind you what those bases are. So which one of these? Do, 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 do. Do, 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 do. Race, color, disability, familial status. Now, you can't say all of them now. I mean, it's one of them. The number one basis is, drum roll, disability. Now, disability is number one, and not only in the state of Florida, but also across the country. Approximately 62% of complaints filed within the state is disability and across the country. That's employment and fair housing. Number two, for employment, would be retaliation. Under housing, it would be race. But let's talk about housing for a second. I just told you disability is 62%. Guess what the percentage would be for race? 58? 58, 35, 32, da, 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 da. So 23. 62%, 25%. Why do I bring this up? Because we just talked about what the word discrimination is. And the word sometimes is hijacked with race or gender, but it's actually disability. That's a high percentage. Now, let's explain why. This is my first time here at Family Cafe, and coming here, I was just amazed. I told you my colleague who actually just walked in, Ms. Lazardo, one of our senior attorneys, she prepared me a little bit, but to see the beautiful array, I was just like, wow, there are so many people. And this is just a scratch of the surface. So, I'm gonna give you a little exercise. Generally speaking, please, everyone say generally speaking. Okay, look around the room. Can you generally tell who's male or female? Generally, please, for those that are watching, generally. Okay, just one. Can you generally tell the gender or if someone is race? Generally speaking, generally. Now, aside from this handsome gentleman here who is in this motorcade, I know Secret Service is outside. Can you look and tell me who is disabled? And the young lady here that's beside him, that's his escort. Can you tell who's disabled? Just by looking at them. Disability is one of these classes where when you're born, you could potentially be disabled or not. When you're a child, you could be disabled or not. When you're an adult, senior, and you can define what senior ever is, so I'm not going to give you an age. Or through the workings of modern medicine, you may become non-disabled, but yet you're still protected. So everybody in here can be disabled, or everybody could not. Hence 62%, 25%. But yet, the noise or the information outside says, hey, we're being treated different because of this. And actually, this is the higher percentage. So, let me move on. All right, so with our agency, I'm going to give you a very simple way on how we handle complaints. And by the way, FCHR means Florida Commission on Human Relations. I don't make any assumptions. Want to make sure everyone understands that. So what happens is we review a complaint, we investigate the complaint, issue what's called a determination. That means we determine whether it's cause or no cause. Now, our agency is considered what's called an administrative agency. That means by law, we have to investigate the complaint, and we make a decision on whether or not, based upon the facts, have a complaint been determined to be cause enough to believe that discrimination took place, or unfortunately no cause to believe that discrimination took place. We are not a legal authority. You would have to take that to the next level to go to court. But you can't go to court until you go through an administrative agency, which is us. So we can't answer legal questions. We can't tell you what is. And okay, let me tell you what happened. So on this, right, you have to go through the process. And while we are very equipped to give you the information as far as the guidance is concerned of how we do what we do, we can't tell you what you should do, what you shouldn't do, and I would think about this. So, basic general facts. First of all, if you have a complaint, you have up to 1 year, 365 days, thousands of hours, 36, break it down how you would like, to file a complaint. And that's from the date of harm. So if something happens to you today, June 14th, you have until next June of next year. Now, if it's a leap year, you might want to minus it, that day. Okay. Once a case is filed with our agency, we have up to 180 days to file a complaint. Now, if it's a housing complaint, we have 100 days to file a complaint. So that is something we are statutory mandatory to do. So when we get it in, we are rolling. We are rolling. So also, I just said we have federal and state relationships. You cannot, unfortunately, I say fortunately, but unfortunately, cannot file with both agencies. If you file with us as a state agency, you can't go file, well, I want to make sure both are covered. They're going to send it to us anyway. You can't have two duplicate investigations. And again, as I stated before, if you file with us, your federal and state rights are protected. So let's talk about specifically, since we're at Family Cafe, ADA. Just want to kind of give a kind of basic overview. First of all, it was established in 1990, July 26, and amended in 2008. And the statute actually includes service animals. And it's divided into different sections. And the reason why I bring this up, because a lot of times we get a lot of complaints that I just told you. We cover 4 areas: employment, fair housing, public accommodations, state whistleblower retaliation. But they call us for all different type of things, such as public entities and telecommunications and commercial facilities. Yes, all that is covered under ADA, but our agency does not specifically deal with that. We primarily deal with employment and public accommodation. So, 9 areas that are covered: agriculture, education, employment. Ding, that's us. We can help you there. Health and Human Services, housing. Ding, we can help you there. Labor, workforce participation, land, resources, environment, transportation, and other governmental functions. So ADA touches everybody's life, whether you're disabled or not, associated with. Okay? So I just want to kind of give that as a background, as a foundation, because we are not the end all be all. So, as I stated before, giving you the definition what ADA is: physical or mental impairment that substantially limits one or more major life activities, has a history of having such an impairment, or is perceived to having such an impairment, or a person that has scars from a severe burn, things of that particular sort as well. So, when we conduct an investigation, this is the framework on how we do it. Do we determine the person is disabled based upon those particular factors? Now, a person does not have to necessarily reveal what the actual medical condition is, but it does have to be verified that they do have a disability. And we get that for receiving a medical certification from their doctor. So there is state law that does indicate that if there's attempts of fraud, that a person could be prosecuted. Now, we're not going to be the prosecuting, but it stands to reason that if you're trying to get over, that some way or another you could be caught. Also, was that person subjected to a substantial adverse action? Were they fired? Were they terminated? Were they treated differently? Something that harmed the particular individual. And here's the thing that most people need to understand. Even with the disability, are you qualified to do the job? One of the things that a lot of employers have to understand, and also those who are filing complaints, is even if you have a disability, can you still do the job? If the requirements say it takes 2 years of certain level of experience, and you have 6 months of experience, are you qualified? No, because you have not met the basic requirements. So a person can't just say, oh, the reason why they're doing this is because I told them I have a disability, or the reason why because they can see I have a disability. No. Did you meet the minimum qualifications? That's number one. Number two, can you do the job even with the disability? So if I have a disability concerning my back, and the job is to be a gymnast, can I do it with or without accommodation? You need to stop being in my classes. Okay, you stand outside. Exactly. It depends. I told you all before, do not just make the assumption that, oh, it's this or it's not this. But you let the investigation dictate that, because there is a possibility that there may be discrimination based upon what is being asked of that particular individual. And the young man said that for those that couldn't hear all the way in the back, what if that person is going to be a coach of being a gymnast? This could have been a rising star in D1 college and in AAU, but a freak accident happened, but their mind is still sharp. So I'm applying to be a gymnast coach. And they say, oh, I don't know, yeah, I think it's because of my disability. That could be a possibility. The essential job functions and tasks that are fundamental to performing this position. Here is what I want everyone to make sure they understand. When we're talking about can you do the job with or without an accommodation, we're talking about the main task. What you do not want to get caught up in is if you can't do what we call non-essential tasks. I'll give you an example. If I'm a mail clerk, the job of the mail clerk is to sort the mail and make sure it goes out. Now, unfortunately, there are times we get heavy boxes that I have to lift up, put it on the mail sorter, and sort it out. But my job is to sort the mail. So if I have that back condition that's a disability, and I'm trying to get that position, oh, well, Dante says you can't lift it on the table, we're not going to be able to hire you. Whoa, wait a minute. Is lifting the box the essential aspect of the job, or is to get the mail out? Because if someone can come and just lift it up for me, that could be an accommodation. So you can't restrict me because I can't do a marginal task. So hear what I say when you're looking at particular jobs and or you're asking for an accommodation. Is it essential or is it marginal? Yes, I have a question.
What about a male applying at Hooters, for example? The essential function is to serve food, but it's marginal to their the outfit.
Okay, so the question was, and I've had this question before, what about Hooters when a male is applying for a particular position? There was actually a lawsuit that a male person trying to get a server position, and the male person won because the essential function was to serve food. But it says Hooters, but the serving job was, welcome to Hooters, I'm going to take your order. So it's not essential for them to be a female. So in that particular sense, yes, that in that particular case, it was discriminatory. So that was actually a lawsuit that the extra person won. So again, an employee cannot be denied a position if they cannot perform marginal job functions if they are qualified to do the essential functions. So when you're looking at job duties, when you're looking at anything that requires some type of work, can you, with your disability, do the essential functions of it? Okay? Now, with that said, if you can or cannot, can you do it with a reasonable accommodation? Reasonable accommodation is basically, I need assistance. It is not getting over. It is not breaking the rules. It's not more than, less than. It means I need assistance to be able to do the job. So the little example that I just gave you about being a mail clerk, as long as I have an accommodation to help lift that box, I can do everything else. What that does not mean is I can do less than. So if I'm required to do 10 pounds of mail as far as getting sorted, I can't say, well, because I'm disabled, I can't do the 10 pounds. No, the requirement is still, we got to have 10 pounds because it's got to go out. Your disability is just limiting you from actually doing lifting. But if someone is actually doing the lifting or that's being resolved, you can still do the essential functions of the job. And that's what you're going to be graded on. A disability does not prevent you from being disciplined if you break the rules. What I like to say is a reasonable accommodation is like a key to a door. You're just trying to get access. Once you're inside that door, you have to be like everybody else. Because if persons give persons with disability more deferential treatment, then they're actually discriminating against persons who are non. It goes both ways. You have a question, sir?
Yes, regarding what you were saying. Okay, I worked at Walmart. I carry heavy boxes that are empty, and I have a team that helps me unload boxes, dump them, and plus carry them all the way to the back.
So
What I'm saying is, there's a lot more stuff to it.
Mm-hmm.
We we all work together, is what I'm saying.
That's wonderful.
Yeah. Because a lot of people, what the hell is this guy doing? Pushing boxes. So I do it all, and carrying big bags of trash. So I'm pretty much see what you're saying.
And that is awesome that your location, what he was saying for those that may not have heard, as far as he works at a particular location, which I shall not name, that basically is a team effort. That while he's in a motorized vehicle, does it have spinners on it, by the way? I'm just curious. He carries boxes, but he also has team members that actually helps him lift them. And that is an awesome thing. But a lot of places may or may not have that same mentality. What I want everyone to understand is the purpose of these particular laws is to ensure persons with disability have the same equal access as anyone else. And a lot of times, employers can be sometimes short-sighted on thinking someone can or cannot do something. And they can be very limited as far as, well, I need you to do this. Well, why is it important for me to do this? If someone can do this and it can still get done and it's not interfering with the business aspect of it, then why are you so bent on me doing that? That's kind of the aspect of what we're talking about in terms of making sure persons have the ability to still do the essential functions of their job. Now, yes, ma'am.
That first one must be personal accommodation. Does that have to be on the job application?
No. So when we're talking about requesting accommodation, the question was, does it have to be on a job application? No, does not have to be. You can ask it during your interview. You can ask it while as an employee. But it has to be essential for that. Now, I understand that a lot of persons are very skittish about, I don't want to say anything that might hinder, because in the back room, you don't know, was that considered against me and all that kind of stuff. So we're not going to put our heads in the sand and act like certain things don't happen. Let's not play these games now. We're talking about real life. Yes, I'm talking about what the rules and responsibilities are, but we're not going to sit here and act like things like that don't happen. My job is to educate you and to empower both the public and employers. We are a neutral agency. We don't get any joy out of saying cause or no cause. Our job is to try to make sure we don't need to be used. But because we have people, if there's only 2 people on earth, I don't like that leaf. No, that leaf is too big. No, that's a big coconut. No, that's a little coconut. Somebody's going to have conflict. And our job is to basically make sure that everyone's treated equitably and fairly. Yes?
Do you guys have people that go to a job site and train the manager on how to deal with people with disabilities? Because with my job, my boss, she has a kid with disabilities, but I don't think everyone understands how to deal with people with disabilities. How to help them, because there's a few other employees, not just me with a disability.
Well, the question was, do persons go on the people jobs? There are profits, nonprofits, and I kind of did a little bit, that if the employer requests that, it's not mandatory, unfortunately. The thing about it is, ignorance is not a defense. So once a violation is taking place, you can't say, oh, I'm sorry, I ain't know. Well, then that person's at the mercy on whether or not a complaint is going to be filed. So it's not a matter of, well, I didn't know, So there are services out there, and at the end, I'll highlight those particular resources they can go to, one in particular, but it's really at their discretion. I like to say this statement. People don't know what they don't know. And when they think they know, guess what? They still don't know. Which is why I have a job. All right. So the employer may request medical information and documentation on the disability, and because it's necessary for the employee to perform the essential functions. Okay, let me go ahead and dispel this little myth. Requesting information is not a HIPAA violation. That is not the same thing. We constantly are hearing that, oh, that's a HIPAA violation. I don't have to tell them. No, that's not. An employer does have a right to get the basic information to verify whether or not you have a need for the disability, need for the accommodation, and what the accommodation actually is. Okay? And the accommodation has to be effective. So it just can't be, so if person needs a chair to sit in, well, I'll just give them this little step stool. That's not the same thing. Well, I accommodated them. That's not the same thing. It has to meet the need. So there's a term called the interactive process that I'll talk about in the next slide. But the accommodation also cannot be undue hardship. I'll use a very simple example for a housing complaint. So this place, beautiful place, you're in the wheelchair, and I want to live here, but it does not have steps. It does not have a ramp, does not have a... So your accommodation request is, I want an elevator in this place. Well, an elevator is expensive. It's going to change the actual function of that particular place. So the likelihood of that accommodation request is going to be 0. So then you're like, you know what? I'm going to file a complaint with the Florida Commission on Human Relations. I asked for an elevator and they didn't give it to me. Well, yes, you did ask for an elevator, reasonable accommodation, but was it reasonable and did it cause an undue hardship? Now, I just told you that the accommodation has to be effective. Well, we can't give you an elevator, but how about we give you this nice ramp that's going to take you straight to your door? I don't want a ramp. I don't feel like rolling my arms. I get tired. I'm tired. When I get home, I just want that nice elevator just to lift me up and take me in. Well, the ramp will actually meet your need. So because that's not what you want, that doesn't mean that the reasonable accommodation has not been met. So reasonable accommodation is not, do I like it or do I not like it? Is it going to meet what I need? On the flip side, you want a ramp. Just want a simple ramp. The housing says, no, we have beautiful oaks here. It's not going to match our aesthetic. That is not a legitimate reason to turn down a reasonable accommodation complaint because it doesn't look good. Or, well, if you get a ramp, we have to have it in these 3 colors. If the ramp only comes in black, but they want it to be fuchsia, lilac, or whatever the color, purple, I'd like to say. You can't restrict it because it doesn't meet the aesthetic need. The bottom line is for the interactive process is, does it meet the need of the individual? And the accommodation does not have to be traditional. So you can think outside of the box. And that's where a lot of employers get also hung up as well, and housing providers get hung up as well. Well, I've never heard of that. Well, okay, but is it going to meet the need? Is it reasonable? Guess what? You should do it. Also, to say it's an undue financial hardship, that's a high element for an employer or a housing provider or organization to say. Now, just because you're cheap doesn't mean that you still have a responsibility to not do what you're supposed to do. And when we say the interactive process, it has to be a reasonable time frame. I understand the priority, but just because you ask for it on Monday and don't hear from on Wednesday, please don't file a complaint on Friday. You haven't given them enough time. That we say reasonable. Now, you applied June 14th. You haven't heard anything on July 14th. That might be a problem. So, and there is no specific time frame on, well, is it 10 days, is it 15 days, or 20 days? It's a case-by-case scenario depending upon the particular process. Okay. Last thing I want to talk about, this is part of the hottest topic, an area of misinformation in the country. Service animals versus more support animals. Because I want to make sure I give you time for questions. First of all, service animals and emotional support animals are not the same thing. Service animals are a dog that is individually trained to work or perform tasks with a disability. Thank you. The service animal has to do a particular task, whether it's, of course, the most obvious ones are the seeing eye dogs. But what about those that can detect if someone's going to have seizures or things of that particular? So they're actually working. So when you see a service animal, I'm on the clock. Now, unfortunately, service animals don't have a off the clock, but they may feel like they want. Hey, I'm tired. I need a break. Also, service animals are this: dogs and miniature horses only. So for those of a certain age group, baby Mr. Ed. Now, so if you see a cat, if you see a giraffe, if you see a raccoon, it is not a service animal. And with service animals, state and local governments, nonprofits, they have to allow service animals to accompany with persons with disability. All right? Emotional support animals. They provide companionship, assist with anxiety, depression, and certain phobias. Any animal can be an emotional support animal, and training is not required. Emotional support animals are just there. They look to the left, look straight, eat, go to the bathroom. Look to the left, eat, go to the bathroom. That's all they do. They're emotional support animals. So they're not doing anything, but they are providing particular comfort. That is not the same thing as a service animal. And here's the thing that a lot of people don't understand and don't realize. Emotional support animals are not covered under the Americans with Disabilities Act. I'm going to say that again. Emotional support animals are not covered under the ADA. So therefore, if you have an emotional support animal and you're going into different businesses, that business does have the right to ask you to leave because it is not a service animal. Emotional support animals are covered under the Fair Housing Act. So if you're dealing with a housing transaction, then yes, that is required for them to do that. And if I have the other opportunity, I would take some more time to kind of delve into that. So, Sarah, if you invite me back, good to go. Yes, ma'am.
Real quick, 'cause, you said it is for housing. So does that mean if you have an emotional support animal, are they able to charge you? Like give it an extra rent because you have this
No.
emotional support?
That's the short answer. So for under Fair Housing Act, first of all, emotional and support animals are not pets. So therefore, they are considered to be an extension of who you are. So housing providers cannot do anything different. They can't charge rent. They can't charge extra. They can't do anything that is more than like pet fees. They cannot charge you, for that as well. There's also no particular weight. Again, Sarah, you got to bring me back so I can just talk about emotional support animals. Yes, ma'am.
I'm a peer advocate, and the two most important documents, if you want to know about this topic for housing, is going to be the DOJ HUD Joint Statement from 2004 and the FCHR 2020 guidance, which outlines if you're applying for a service animal, what they can and can ask for, or an emotional support animal.
Also, I brought goodies for everybody. That has information about service housing. I don't want to have my back to it. I have a few more minutes before I have to get. So, a housing provider, as I stated, can request for reliable information. The reason supports having a disability. And again, the housing provider has to do the interactive process to make sure that that person's needs are met. Now, concerning that, what the young lady just said, as far as she's talking about going to the DOJ or going into the FHEO, which is the Fair Housing Employment, I forgot what the O is. You can go to HUD.gov to get that information. However, know this, there is no requirement to have specific documentation. As long as you have certified medical information from your doctor indicating there's a need for it, then that is sufficient. So if anybody tells you you have to fill out a specific document, that is false. Here's another thing that is very, how should I say, controversial. It is not required for a service animal to have identification. That is not a law. So when you see individuals saying they went online, I have a service animal, it's not required. So organizations, businesses have the right to question you whether or not it's a legitimate service animal. But they can only ask 2 questions. Number 1, is it a service animal? Yes, it is. Number 2, what service does it provide? Those are the only 2 questions that they can ask. If they ask anything else, you don't have to answer, and it's not required. Now, one law cannot supersede another law. So, if you want to take your service animal to an all-you-can-eat restaurant, that public accommodation place has to allow you to come in. However, you can't take Fluffy up to the hot bar. That's now going to be a violation of health and security. But what that restaurant or provider can do and is supposed to do is to provide assistance, saying, okay, since you can't bring your service animal with you and you need your service animal, we will have someone to help you to get your food or provide that for you. That is what they're supposed to do. So you can't say, you can't let me do that. Actually, no. There is case law that defends that. So we were talking about that interactive process. So there has to be a dance. Also, if you have a service animal, you cannot be restricted into any particular, well, we're going to push you over here. No, you have the right to sit wherever you want to sit. And so that's where we have a lot of controversial, we were talking about these things right here. There are things that are in court that's being dealt with. There are things that are being advocated back and forth. So, but as far as for basic guidelines, the protections are there for you. And finally, these are some of the resources of information that you can get. For the young lady here in front, you were talking about your employer. I recommend you talk about the Job Accommodation Network called Ask Jan. They help employers deal with specific circumstances. Because again, accommodations do not have to be traditional. So you can call them, contact them, give them your particular need, and they may give you some suggestions. Also, the employer themselves can contact them and give them guidance. We can't give you that guidance. All we can say is do the best you can. All right. Any questions? I have 3 minutes before I do a heart. I have this lady in the back, and then this young lady. Yes, ma'am. Okay, so we are not HR. Every organization has their own HR. We are an agency that investigates. So we cover so we're not, and that's the other thing too. We do get a lot of, we're not your HR. So what I say that, and it's a case-by-case scenario. You can go to your HR to try to handle certain things, but we can supersede because we're investigating under state and federal. So if you're trying to do an internal investigation, that's something separate. But if you feel like something has to take place, it is your prerogative to come and file to us. We're not going to say, did you go to them first? That's not what we do. We're going to look at whatever complaints that you're going to go for. Second question.
Is there any protections for like certifications? A very specific example, FAA medical license certification for being a pilot. Can they deny it just based on a diagnosis, even if there is no like actual disability that would not make them able to do the job?
Okay, so the simple answer is it depends on what the findings are. First of all, if the person is alleging they were not hired because of disability, we would have to find out from the company what was the legitimate non-discriminatory reason. The ultimate burden is going to be on the person filing the complaint saying it was because of disability, because of these particular factors. In your particular situation, they would have to follow their guidance. And if it's because of a particular thing, as long as it's non-discriminatory and it's not based upon a person's disability, or not a perception, or being regarded as, and they have a legitimate reason, then it may hold. Otherwise, it may not.
So if we're fighting against those,
I will always say this: file a complaint and let the investigation do the work. And this young lady right here, I think this was going to be my last question.
The question that I had was that if you're with a larger company that has a union that is dealing with a termination, is it better to stick with the union or still file a complaint with you guys?
I'm going to say you need to check with your personal legal counsel because that's not a question that I can answer. Our authority is the federal and state law. So regardless of whatever union, non-union, you have to make what's in the best interest of you and yourself. That does not affect how we do our job. We're going to look at, you filed a complaint, we're going to investigate it. So that's a question that you would have to talk with your loved ones, get legal counsel, get guidance concern. You can contact your local legal aid or contact the Florida Bar Association to give you guidance on that. So I do have a QR code for you can rate me to see if I need to do a better job concerning that. And again, thank you, Family Cafe, for inviting me. And go have a great day. I do have brochures up front that talks about service animals and also the agency as well. If you have any questions of me, you can come and ask me. I still cannot give legal counsel or advice. I only sleep in the Hyatt Regency, just not, I'm the expert. But thank you so much.